We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And we're back on Liberty Nation Radio, heard coast to coast on the Radio America Network. I'm still your host, Mark Angelides, and we are again joined by Liberty Nation's Legal Affairs Editor, Scott Cosenza. Now, in the first part of the show, we started off talking Scott Cosenza's Desert Island top 5 Supreme Court cases for the upcoming Supreme Court term. We did 2 down. We've done 2, so we've got 3 more left. Which one comes in next, Scott?
We had, was it Marvin Gaye and Pink Floyd already, right? So
we did
wait,
those. If you want to find out specifically which tracks, go back
list.
and watch the first segment.
Right. All right. Garland v. Vanderstock is next, and that concerns
presumably this
ghost...
is Merrick rather than Judy.
That is a ghost gun case. This is the passion of, there are some the low-hanging fruit, if you will, for those who wish to increase gun controls on the American people. It is an easy sell, I think, for a lot of people to suggest that it's not okay to have unregisterable guns. These are guns that are essentially homemade guns. With the advent of 3D printing, there's been a remarkable use of that. I think it was the guy who invented the 3D printed AR-15, Corey, I forget his last name, but I think he said, I'm just trying to give appropriate credit for the idea because it's not mine. At some point in the not too distant future, any gun control is going to be silly because the ability to print at home robust guns that require no expensive machining is coming. And once it does, just having that file is all you'll need. Just like having a Word document file is all you need to go then, turn on your computer and tell your computer to print that file. And the same thing will be true with guns. But until then, anyway, before it's superfluous, there's a regulation that bans the ghost guns or allows the government to regulate them as firearms and therefore effectively, sort of ban their homemade production. And the Texas judge, a conservative, Texas is really out there in terms of, we used to joke about the Ninth Circuit being wildly kind of on left wing, bleeding edge. And now the Fifth Circuit Court of Appeals and the Texas judiciary sort of that for the right. And we can look at abortion decisions and gun decisions as we talk about that. But basically they said, hey, you can't regulate these things as firearms. You're banned from doing so. The people's right to keep and bear arms includes to manufacture ghost guns and not have them regulated like firearms, requiring, for instance, filing of forms and imposition of serial numbers on the devices. Well, the Supreme Court granted the government an emergency stay from that decision. So they said, okay, while we're going to think about and then ultimately decide this case at the Supreme Court, you can still enforce a ban on ghost guns. So this will decide that rule. Can the government treat ghost guns like regular firearms?
I have a suspicion that this will end up actually back at the Supreme Court again, because there's bound to be a follow-on challenge if Mr. Garland fails to get his way on this, I should suspect.
It's never-endingly frustrating for me, Mark, when the Supreme Court rules, especially on gun cases, when you know that the rule that they establish is immediately going to be challenged or require fine-tuning, and they don't just go the extra step of doing it. However, it is in their mandate for good jurisprudence to judge as little as they can, if you will, right? Because it is an anti-democratic process, the Supreme Court, and they're not gods, and so it's better to leave as much to the political process as possible while constraining themselves to the core issue that must be examined. So it's frustrating for me when it happens like that too, but also it's for the greater good that they only take as small a bite as they have to on any
leave
issue.
the apple largely intact. So number 2 on your list, Scott.
Well, we're not at number 2 because we already had the first segment, Mark, where we discussed the first 2.
Sorry,
so that
one of the
3.
remaining 2.
Now
so number 4 on your list.
Number 4, right? Lest we have me lose my place, and it is United States versus Scrimeti, and that is an issue as to whether or not it's legal for Tennessee to prohibit all medical treatment intended to, and I'll quote here, allow a minor to identify with or live as a purported identity inconsistent with the minor's sex. So basically, the Tennessee authorities said to doctors in the state, you can't do this gender affirming care and have trans minors be transitioned, I guess, or even more, as the text indicates. And there's the claim that violates the Equal Protection Clause, that they have the right to be treated for their medical needs, which is what they're considering this, and that this is an illegal imposition on that. And so it's, the first time, I think, or well, I guess the bathroom issue was the first, but this is the first time the medical transitioning issue, I think, has reached the court. And I expect, as transitioners and detransitioners continue to kind of become adults, we're going to see more interesting cases around these issues.
I suspect this will balloon into possibly one of the most important issues of the next decade. And unfortunately, there's always going to be a human cost to that. So, Scott, your remaining top pick for
this is I thought kind of interesting. This is called Facebook versus Amalgamated Bank. And what Facebook did was they filed a disclosure with the SEC, the Securities and Exchange Commission, discussing the hypothetical damage that could be done if their users' data was misappropriated. And they talked about it as a hypothetical, but it had already occurred. Like Cambridge Analytica had already misused the user's data. And this is a shareholder derivative suit. The shareholders are saying that the Facebook management committed fraud against the shareholders, because what they should have done was be honest and say, hey, it's not a hypothetical. This happened. You can't couch it as a hypothetical and here's some downside for the company when you know it's happened. You have to say it happened, and then the hits will come in the marketplace, and then the shareholders or would-be shareholders can react. And so I just think it was, an interesting thing about these companies that seem to operate as if the shareholders are the little guy rather than the actual owners of the corporation. It's fun to kick Meta also because of their wanton discrimination against free market and conservative ideas.
Final question for you, Scott. Do you expect over the next term for the composition of the Supreme Court to change?
Well, if we have a presidential election that occurs in November, and that person will then become president in January, hopefully, if things go as they're laid out in the constitutional order. And we have some justices that are getting on in years, and depending on who is president, I wouldn't be surprised to see if one or more of those would announce that they were retiring from the court, and to see new justices appointed. And then there's also the threat from court packing, ever present, Mark.
Ever present. Scott Cosenza, thanks ever so much for being back with us.
Thank you.
We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.